never make a promise on your postscript in your former episode to say you'll have a next episode tomorrow. The CFPB, Consumer Financial Protection Bureau, versus the Community Financial Services Association. The Supreme Court ruled 7-2 in favor of CFPB. Their power is from their appropriation power stems from the 2010 Dodd-Frank Act, which allows it to draw funds from the Federal Reserve up to $374 million, adjusted for inflation. The case came down to the independence of this agency in terms of not being held to the scrutiny that the Congress under appropriations would be held to. And so the two dissenting justices are claiming that the CFPB would enjoy a degree of financial autonomy that a Stuart King would envy. The case was heard in October of last year, and it addresses the constitutionality of the CFPB's funding structure under the Appropriations Clause of the U.S. Constitution. The central argument presented by the CFPB is that the Fifth Circuit's decision, which found the CFPB's funding mechanism unconstitutional, is unprecedented. They asserted that the CFPB's funding mechanism is consistent with the constitutional text and historical practices. They argue that the framers of the Constitution explicitly restricted appropriations for the Army to 2 years, but did not impose similar limitations on other agencies. They emphasize that Congress has historically funded various agencies through standing appropriations without time limits, practice dating back to the first Congress. Such mechanisms for agencies like the Customs Service, Post Office, National Mint, and Patent Office. The case rested on the definition of appropriation, and the constitutional provision states, no money shall be drawn from the Treasury but in consequence of appropriations made by law. So on the right, they argue that the CFPB meddles in free markets and is not constrained by the congressional oversight of use of funds. And the two dissenting justices, Alito and Gorsuch, argued that the appropriation is a specific and limiting term, and it extends from the British Parliament's rivalry between expenditures, the power of the purse. And so the CFPB has a mechanism that they're pulling funds from the Federal Reserve, and it's a cap. So there was an argument over the legitimacy of the CFPB. These payday lenders wanted to automatically withdraw money from bank accounts, and the CFPB was against this, but the case rested on the word appropriation, as no money shall be drawn from the Treasury but in consequence of appropriations made by law. In the appropriation clause, the source and purpose of the funds is all that this clause requires. And so there's this argument that the Customs Service and the Post Office had standing authorizations to expend public money in the same way that CFPB funding mechanisms do. The Community Financial Services Association of America had originally contested the number of times they were able to withdraw funds from borrowers' bank accounts, and the Fifth Circuit struck down the regulation, saying it was wholly drawn through the agency's unconstitutional funding scheme. So I wanted to go through the perspectives of each justice and how they viewed the CFPB's funding mechanism and whether it was constitutional. So Justice Roberts expresses skepticism of the CFPB's mechanism, questioning the historical basis. And he's concerned the agency's very aggressive view of Congress's authority under the Appropriations Clause. Justice Thomas focused on whether there are any limits on what Congress can do in relation to appropriation, questioning the CFPB on the constraints. Alito questioned the constitutionality of the language in the Dodd-Frank Act that claims CFPB funds are not government funds or appropriated monies, showing concern over the separation of powers and congressional oversight. Justice Gorsuch highlighted concerns about the potential lack of meaningful limits on the CFP's funding, raising hypotheticals about Congress providing unrestricted funding amounts. Justice Kavanaugh seemed to question the Community Financial Services Association's argument about perpetual funding, noting that future Congresses could still exercise control over the CFPB's budget if needed. Justice Barrett inquired whether the CFSA, that's the Community Financial Services Association, demonstrated that Congress couldn't set up the CFPB's funding mechanism as it did, pointing out that the legislator did specify the funding structure. Justice Sotomayor indicated she did not see the CFPB's funding mechanism as unconstitutional and questioned the CFSA's argument on the problematic nature of the CFPB's funding limits. Justice Kagan and Justice Jackson also suggested through their questioning that they did not believe the CFPB's funding mechanism was unconstitutional. Justice Jackson, in particular, noted that the legislator had exercised its prerogative under the Appropriations Clause. So you can kind of hear between the dissent this concern of autonomy and the power of the purse in Congress and how much government administrative power can intervene on markets on behalf of the current administration. And you've heard this executive privilege come up with the Biden-Hur special counsel, and you've heard it come up with President Trump. But the Stuart King, this era of 1371 to 1603, you had James the First, who succeeded Elizabeth I and was known for commissioning the Bible. Charles I in 1625 saw tensions with Parliament leading to the English Civil War. He was executed in 1649. Charles II restored the throne after the Commonwealth period. His reign is known as the Restoration. And James II opens up Catholicism, autocratic rule, which led to the Glorious Revolution, saw him deposed and replaced by his daughter, Mary II, and her husband, William III. And so these references to Stuart Kings often allude to the conflict with Parliament, particularly regarding issues of royal prerogative and financial control. So, for example, Charles I's dispute with Parliament over financial policies and his attempt to rule without Parliament for 11 years is a classic example of the dangers of unchecked executive power. So General Elizabeth Prelager, on behalf of the petitioners, she's talking about historical precedent and the constitutional text. And her argument is that the Fifth Circuit's decision is unprecedented and that no court has ever held that Congress violated the Appropriations Clause by enacting a funding statute, that the framers of the Constitution only place explicit limits on appropriations for the Army, not for other agencies. So this comes up often where they're talking about the framers didn't want a standing army. So that's why they granted the power of the purse to the Congress to, annually appropriate money. But historical practices show these standing appropriations without time limits are common, starting back with the Customs Agency, the Post Office, the National Mint. But then the respondents argue that the Post Office, only pulls money from a limited source, by fees and your stamps and stuff. And the Customs Service, it was overturned, I think, 1914 by Congress, where it was subject to Treasury ministerial oversight. But Elizabeth goes on to argue about the capped lump sum appropriation. So in case of CFPB, they exercise significant control, which is lower than other agencies' budgets. The example of the 2022 Consolidated Appropriations Act showed more than 400 instances of appropriations allowing discretion up to a specified cap. So they talk about an appropriation. Does it need to be $600 million exactly, or can it be up to that amount? And so you're capping a lump sum appropriation, which is a pretty common practice. This practice aligns with funding mechanisms of other financial regulators like the Federal Reserve Board and the FDIC. They talk about congressional control. The current funding mechanism does not constitute an unconstitutional delegation of power, as Congress defined the source and cap of the funding. Historical and contemporary appropriations often include language that allows spending up to a specified cap. This cap comes up again, maintaining congressional control while allowing executive flexibility. So this argument about the Congress still maintaining control because they've specified the cap as written in the Dodd-Frank. So Dodd-Frank was really Congress starting this flexibility and enabling the executive to have that flexibility up to that specified cap. And Justice Jackson really nails this in two hypotheticals when she's talking to one of the respondents, and she's saying, so what does the appropriation clause actually say? And she gives two scenarios. Does it say that you can only, Congress needs to specify an exact amount, or does the appropriation clause say that they have a right, Congress has a right to define how to appropriate money? And so now you do not have to specify the amount, but rather the source and the fund of the purpose. So it's a very broad stroke, but it's still congressional control of the purse. It's just, what is the power of the purse? And Justice Jackson asked that question. What does that mean, the power of the purse? So to the respondent, Noel Francisco, he's stating that the appropriation clause requires that any spending be in consequence of a congressional appropriation, not an executive determination. Allowing the executive to determine the amount to spend effectively transfers congressional power to the executive, undermining this separation of powers designed to protect individual liberty. So this argument that the delegation authority should rest in the Congress, and that once it relinquishes that into the executive, then the executive now has control of the purse. Definition and the scope of appropriations. The term appropriation should involve Congress setting a fixed amount of money. Delegating this decision to the executive branch violates the clause. Even if appropriations are defined by purpose, i.e. Social Security, Judgment Fund, they're still subject to congressional oversight and limitations. The constitutional and practical implications. Accepting the petitioner's arguments would allow Congress to abdicate its power by setting overly broad appropriations, enabling the executive to spend unlimited amounts without meaningful constraints. Such a practice could create a dangerous precedent, eroding the checks and balances that are fundamental to the Constitution. So these are some of the arguments that highlight the core issue of the sword and the purpose, sword and purse, and whether the CFPB's funding mechanism violates the appropriation clause, giving too much discretion to the executive branch, undermining the congressional control over federal spending. So the argument on behalf of the CFPB, the Solicitor General, Elizabeth B. Prologer, she's really nailing it. She's a Fulbright fellow, studied St. Petersburg, Russia, graduated Harvard Law School, just very well-spoken, and she was nominated by President Biden in 2021 and confirmed in the Senate. Her basic argument is that the majority of the appropriations are standing, and I think it was like 60% and above, they're not restricted necessarily to an annual line item appropriation, which is the argument on the dissent, which is, specificity in the amount. And so this upper limit comes up as an argument for broad discretion that, Hamilton alluded to in the Federalists, that you have to have the separation of the sword and the purse. So there you have it, folks. Because I made a promise to do this episode about this recent Supreme Court decision, I had to jam this down your throat, okay? And I apologize, but I did want to hold true to my promise, and that's why I just pushed this through. And in slow productivity, the natural pace can be really slow, and then all of a sudden it can be fast. And that's kind of how I roll. Is like, okay, sometimes it's hitting me and I just want to go with it. And the thing that struck me about this case was it comes down to this word appropriations. And in that word, you have what is appropriate. And it seems like the divide between the left and the right is what is the appropriate amount of money that should be spent to address problems on behalf of the government.